Chief Justice of the Republic of South Africa, Chief Justice Zondo, distinguished guests, ladies and gentlemen, colleagues. Welcome to this 2024 workshop on public procurement reform in South Africa. My name is Keynote. I'm the Director of the African Procurement Law Unit, and along with my colleague here, Professor Shortwell Williams, Deputy Director of our unit, it is our great pleasure to welcome you to this workshop on procurement law reform in South Africa as we continue our project of engagement on the reform of our procurement system. When we started this project of facilitating a national conversation on procurement reform in South Africa last year, I opened the first workshop in February 2023 in this very room with a quote from Chief Justice Zondo. And I thought that it's only appropriate with him present today that I repeat that quote. When he said in the Commission report of the State Capture Commission the following, and I quote, "Any serious attempt to address the problems which beset public procurement must go well beyond state capture. It must assess the adequacy of the procurement framework which is set out in the national legislation to see where that framework is compatible with the realities on the ground or whether there are fundamental design deficiencies. The process of reform requires a coherent and comprehensive plan of action which needs to bring the public and private sectors together in a joint initiative to restore proper standards and discipline within the procurement system." End quote. That statement by the Chief Justice was the inspiration for this project, and which has brought a broad range of stakeholders in public procurement in South Africa together again here today for the third installment in our ongoing conversation. As academics based at universities both inside and outside South Africa with a keen interest in public procurement, we at the APLU aim to continue facilitating a constructive conversation on aligning our country's procurement framework with the realities on the ground. We wholeheartedly share the Chief Justice's sentiments that the key for successful reform of our procurement system lies in collaboration. This project is a collective process of reflection on what public procurement system we want and need in South Africa and how we can collaborate to get there. The timing of our conversation today and tomorrow could not have been better. I wish that I could claim that I had the kind of influence to get the President to hold off on assenting to the public procurement talk to the day before our workshop, but I'm afraid it is nothing more than happy coincidence. Although one may perhaps say that it is the universe telling us that we are on the right track in bringing together the public procurement community for this collective reflection. The fact that we now have a Public Procurement Act, Act 28 of 2024, there's a nice ring to it, 28 of 2024, is no small development. It is, of course, the first comprehensive procurement statute that we've ever had in South Africa. It consolidates our hitherto fragmented and often ad hoc procurement law. The Act has been years in the making, and its presidential assent yesterday is certainly an achievement on which we should congratulate our colleagues at National Treasury. We should, at the same time, caution against complacency and thinking that the work is now done. Firstly, much work remains before the new Act can be implemented. Significantly, the drafting of the regulations necessary to flesh out the Act, a topic that we'll spend a considerable amount of time on during the next 2 days. But secondly, and perhaps more important, we should not fall into the trap of thinking that the creation of a new Act will magically solve our procurement challenges. law on its own cannot solve our problems. It is only the first step, albeit a very important first step. Once we have established a new regulatory framework, we have to continue working on making that framework a reality by focusing on all aspects of the system necessary to realize our Constitution's vision of a procurement system that is fair, equitable, transparent, competitive, and cost-effective. Those 5 magic principles that all public procurers in South Africa should live by. It is towards the achievement of that goal that I hope each and every participant will actively and constructively contribute to our engagement over these 2 days. To start our conversation, it is now my great privilege to introduce our guest of honor and keynote speaker, Chief Justice Raymond Zondo. Chief Justice Zondo obtained his B.Juris degree from the University of Zululand and his LLB from the then University of Natal, whereafter he completed no less than 3 master's degrees in law. Justice Zondo practiced law as a partner in the Durban law firm Mattei and Zondo Incorporated until he was appointed as a judge of the Labour Court in 1997. He brought a wealth of knowledge to the Labour Court, not only based on his experience as a member of the ministerial task team that produced the draft Labour Relations Bill for Labour Relations in post-apartheid South Africa, which became the Labour Relations Act 1995, but also as the first chairperson of the board of the CCMA. In 1999, Justice Zondo was appointed as a judge of the High Court in Pretoria, and in 2000 as the Judge President of the Labour Appeal Court and Labour Court. On 1 September 2012, Justice Zondo was appointed as a Justice of the Constitutional Court, and 5 years later as the Deputy Chief Justice. Between 2018 and 2022, Justice Zondo served as the chairperson of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state. A commission that we, of course, all simply know as the Zondo Commission. On 1 April 2022, Justice Zondo became the 6th Chief Justice of Democratic South Africa. As I noted in my opening remarks, Justice Zondo is no stranger to public procurement reform. As chair of the State Capture Commission, he became intimately familiar with public procurement and put forward a bold reform agenda for public procurement in the Commission's recommendations. It is thus a great pleasure to invite Justice Zondo to address us here today. Thank you, Justice.
For some of us who are not so tall, these things have to be adjusted. Thank you very much, Prof, for those very kind words with which you have introduced me to this gathering. Let me begin by saying, distinguished guests, ladies and gentlemen, I feel very, very honored that the organizers of this workshop considered it appropriate to invite me to be with you this morning and to share some of my thoughts this morning with you. I have a sense that many of you have been involved in discussions on public procurement for South Africa for a very long time, probably much longer than I may have been involved, because my involvement was very much during the time of the commission. But I want to emphasize that I'm really pleased to be part of this gathering this morning. And I'm particularly glad that the organizers of this workshop were able to ultimately pin me down to ensure that I accepted the invitation to deliver this keynote address. Because last year they did invite me when you were going to have last year's workshop, or was it 2022? Last year. And I was not able to accept the invitation because of other commitments, but they renewed their request later on, and I was able to agree. And to show how determined they were that I should be here, they said, we'll plan everything around your availability. So once people say that, you know that they really want you to be part of the gathering. So I'm very glad that I was able to ensure that my schedule permitted me to be here this morning. The organizers and I didn't agree on a topic that I would talk on, but of course I am aware of the theme that you are all going to be discussing. I thought that this occasion should be an occasion when I can go back to the work of the Commission and remind all of us of some of the challenges in public procurement that we came across in the Commission, so that as you proceed with your deliberations and looking at the Public Procurement Act and other measures, you can look at what the challenges were that were identified by the Commission that are supposed to be addressed, and that you would look at whether the Act addresses those adequately. In this regard, I think I must immediately say that it might be a little awkward for me to speak at a gathering such as this, because I made certain recommendations, and of course government was under no obligation to accept all my recommendations, and therefore whatever I say, I need to remember that just because I made a recommendation, it didn't mean that government should accept all of them. And indeed, even if it didn't accept many of them, I should respect that. It would then, of course, be up to participants in a gathering such as this to inquire into whether or not government responded adequately through a measure such as the Public Procurement Act to the findings and the recommendations of the Commission. It would be up to a gathering such as this to say, or to ask the question, to what extent will this measure ensure that the problems which were sought to be addressed will be addressed and will not recur. So you will forgive me if I spend more time talking about what the challenges were that the Commission found than comparing the measures taken by government and saying whether they are good or not good. I think I should leave that to you. I wish to begin by emphasizing that there is no doubt that the greatest part of corruption in our country is tied up with public procurement. If we were to succeed in even having the corruption that is connected with public procurement in this country, we would have saved billions and billions of public funds that would have gone to corruption, that would then be used to ensure service delivery and to ensure that the lives of South Africans are improved. It is difficult to think in the context of South Africa of a lot of corruption that happens outside of public procurement. Therefore, when the Commission began its work, we were very much aware that we were called upon to identify exactly what the problems were in mainly public procurement, and that we were called upon to come up with recommendations that will ensure that in South Africa, corruption after the Commission would not be the same as corruption before the Commission. In one of the first media briefings that I had as chairperson of the Commission, I was asked by a journalist to state what the mandate of the Commission was. And apart from talking about state capture, I said that it was to identify the nature and extent of corruption in South Africa, to identify what it was that made corruption so deep in our country, to identify participants in corruption, and to come up with measures or recommendations that would make sure that corruption was reduced drastically in South Africa. And I said in that regard that it was the intention of the Commission to make sure that it followed evidence in its work and followed that evidence up to whoever the evidence led the Commission to, irrespective of what their positions were, irrespective of what their positions had been, and irrespective of what their positions were likely to be in the future. The instruction to the investigators where it doesn't matter what position a person occupies, or what they occupied in the past, or what the position they are likely to occupy in the future. if the evidence led to that person, they must follow that person. And I believe that that is what the commission did. The investigations of the commission were not simply about corruption, they were also about state capture. And of course, the two are linked. As you will remember, the commission looked at the evidence involving various SOEs and certain government departments, and it unearthed mountains and mountains of evidence of corruption. How was this corruption taking place? I can mention and refresh your memory because these are matters that you will remember from the evidence of the commission and the report of the commission. I can mention a few ways in which the corruption was taking place. You'll find that certain services were procured even though they were not necessary, and even though there was adequate capacity within a government entity. We know that that happened at Transnet when, despite there being adequate capacity within Treasury at Transnet, Treasury services were sought from outside. We know that that happened also at SARS. Indeed, we know that it also happened at ESCOM. There were even instances where parallel advisory services were secured for the same service in the same project. This is what happened at Transnet when regiments and children were secured to provide the same services in circumstances where Transnet had enough capacity to provide those services. And when, of course, I remind you, as I do, of how corruption was happening, was taking place, and how it was done, think about how the measures that are being put in place are going to minimize the prospects that those same challenges happen, or how they will make sure that those challenges do not happen again. Because if the measures that are being put in place are not to bring about a significant difference in those instances of corruption, or if they are not going to ensure that those types of corruption happen again, then the measures that are being put in place, it will mean, are not effective. That underlines the importance of this kind of workshop, because it is you who must look at these measures that government is putting in place. Look at what the problems are that they are meant to solve, and ask the question, will they solve this problem? If they won't, what are the solutions? What are the measures which government has not taken which will solve these problems? And why has government not adopted those measures? Because the corruption that we have endured in South Africa over the past 8 years can simply not be allowed to go into the fourth decade of our democracy, and can never be allowed to be a feature of the next 30 years. There must be a change. There must be a difference. And if we can't make a difference on corruption in South Africa after 30 years, then it is difficult for me to see what it is in which we will make a difference. Because when you look at the public funds that are wasted through corruption, that go to a few when they are meant to assist many, it's just injury. And we can't afford not to be able to see what will work and what will not work. And when we are convinced that something will not work, we must speak out. We must speak out. This is our country. This is our children's future. This is our grandchildren's future. We cannot continue to be known as a country that is high up in the world on corruption. We cannot forget what Mr. Museveni did in the Free State when, in order to avoid his department returning unspent funds back to the provincial treasury, he decided that the building contractors would be paid in advance for work that they had not done. And before they could build any houses that they were supposed to build. And he did so without any proper procurement process. Some of these service providers had no expertise in building houses, and ultimately his department in the Free State was unable to point to any significant number of houses that had been built by these contractors which had been paid in advance. I said that I wanted to refresh your memory on how corruption was happening as identified by the Commission, so that as you continue with your discussions and deliberations, these forms of corruption and how they happened will refresh in your mind as you ask the question whether the measures that are being put in place will ensure that these things do not happen again. We know that despite the fact that that incident by the Department of Housing in the Free State happened many years ago, there's been very little in terms of consequences to some of the people who were involved, particularly politicians. At SARS, they came and recommended a restructuring of SARS, which was completely unnecessary, as SARS was doing very well. And ultimately, through that restructuring of SARS, they actually almost brought SARS to its knees. In the Free State, asbestos tobacco, as we called it in the commission reports, a company called Deadhead was awarded a contract for the removal of asbestos in roofs, and it made misrepresentations that it had the necessary skills and expertise, when in fact it had no such expertise or skill. The company opted to subcontract the work, even though when it sought to be awarded the contract, it had not disclosed that it wanted to or planned to subcontract. The commission to review that an entity that is awarded a contract to tender without it having disclosed that it intended to subcontract the work should not be allowed to do so. In other words, a company should declare if it intends to subcontract the work, and it should not subcontract the work only after it has been awarded the contract. The principle is a service provider may not subcontract unless the client has approved the subcontract. Actually, the subcontractor should be disclosed. Otherwise, allowing an entity to bid for work and giving that work to a subcontractor undermines the whole purpose of public procurement, because the work ends up being done by an entity that did not put in a bid for the tender, and public money ends up being paid to an entity that did not put in a bid for the tender. Some of the forms of corruption that took place, as dealt with by the Commission in its report, related to deviations from an open tender. And in this regard, as we all know, Section 217 of the Constitution requires that when an organ of state contracts for goods or services, it must do so in accordance with a system which is fair, equitable, transparent, competitive, and cost-effective. But the regime that has been in place for many years is that there have been different pieces of legislation that deals with public procurement for different sectors. The legislation was fragmented, and as Prof indicated, the Public Procurement Act sits for the first time to try and bring about legislation that will ensure that everyone who wants to know what public procurement legislation says has one place to go to, and not many pieces of legislation that we had before. Although the open tender process is the norm, Treasury did issue regulations which provided for deviations from the normal procurement processes. Deviations were allowed for emergencies and were allowed for those situations where there is one supplier or service provider. An important question, however, has always been how often do government entities abuse the exception relating to an emergency? How often do government entities abuse the exception relating to one supplier or service provider, one source? There are many instances where deviation from the normal bidding process is justified on the basis of an emergency, but when one examines the facts which are supposed to reveal an emergency, one very often finds that there was simply no emergency, and that quite often the exception of an emergency was used in order to ensure corrupt ends in regard to a procurement process. The provision relating to one source has been abused too very extensively, and this was revealed by the Commission in its report. It was used extensively to loot in SOEs. Of course, it does make sense that if there is only one supplier, there should be no need for a competitive process because there are no competitors. However, the investigations of the Commission revealed that there would be many instances where there was no certainty that there was one source. And officials either thought there was one source or knew that there were other sources, suppliers. But because of the corrupt objectives that they wanted to achieve, they said there was one source. In the Commission's report, we took up the issue of one source and made a recommendation that it is better for a competitive or notices to be issued to invite different suppliers to bid and then find that there is only one who responds because there is only one, rather than take the view that there is only one source, only to find later on that you were mistaken and there are other sources, because by then you will have acted in breach of the procurement requirements. I'm aware that this is not one of the recommendations that were accepted by the President, but it seems to me that since it can't cost so much to notify the public that you need particular goods, it is a better way of dealing with it and then avoid acting in breach of the procurement process. The process of confinement was also abused extensively. And in this regard, Transnet had a number of examples where confinement was abused, particularly during the period 2012 to 2015. At least 7 contracts were awarded to McKinsey for various consultancy work by way of a confined tender process, in addition to advisory contracts. The combined value of those contracts at Transnet was about 1.6 billion. Of course, anyone who has spent some time reading the Commission's report or listening to the evidence as it was given during the life of the Commission will remember that a lot of breaches of procurement legislation in various SOPs came about because those officials who are honest, who wanted to protect public funds, who did their job properly, were removed from certain strategic positions. Yeah. And others were put in place who were going to work with those who wanted to loot the SOEs. That connects us with the state capture part of the mandate of the Commission. We will remember that in terms of SOEs, Transnet was the first one to be attacked by the Guptas and their associates. And the starting point, apart from the appointment of Minister Gigaba as Minister of Permanent Affairs in 2010, in December, in their newspaper, the Guptas announced that the next boss of Transnet would be Mr. Brian Death. And indeed, that is what happened a few months later. You will also recall that there was evidence to the effect that a certain Mr. Bester, who had met with Mr. Salim Essa early in 2014, was told by Mr. Salim Essa that the next boss of ESCOM would be Mr. Brian Death. And so it happened. You will also remember that on the 8th of March 2015, at the President's official residence in Durban, a meeting took place which included the chairperson of ESCOM, Mr. Zondo, Mr. Dumieni, and others. And for a certain limited time, President Zuma, at which a plan was discussed to remove certain executives of ESCOM on the pretext that there was a need for an investigation into the affairs of ESCOM, when, of course, we know now that there was no such need. that was simply to provide a pretext in order to have certain executives suspended and ultimately removed from ESCOM. We also know how the board of the NEL that was working very well was allowed to leave in its entirety, except for one person who was not known to have made much of a contribution during the term of the board remained, and the majority of the new members of the board of the NEL were people who had some association with the Guptas. We also know how, following that meeting of the 8th of March 2015, at the official residence of the president, the executives, certain executives in ESCOM were suspended and ultimately removed, and how the chairperson of the board of ESCOM was removed and replaced by somebody who had a close relationship with the Guptas. And we know how after these executives had gone, how ESCOM was reduced. I mention these because when we look at measures that the government has taken to address public procurement, we can't just confine ourselves to corruption pure. We've got to look at also state pressure. And then we have to ask the question, do the measures that are in place, that have been put in place, are they adequate? Are they appropriate to make sure that these things that happened, which led to more than 58 billion francs of South African taxpayers' money being lost, whether they are adequate to make sure that that doesn't happen again? You can't do the one without the other. Well, we may take different views, but I can tell you that in my view, a very important feature of preventing or limiting corruption and preventing state pressure from happening again is making sure that when it comes to key strategic positions in the public service, we have public servants who have integrity. There are many public servants that the Commission heard about who resisted attempts to get them to be involved in state pressure and to engage in wrongdoing. You can go to SAA, Dr. Dawa was one of them, Ms. Michelle was another one of them. You go to ESCOM, those executives who were removed permanently, they were removed because the voters had got enough information that they were not going to pay more. What has government put in place that will make sure that in key strategic positions, public servants and officials will be people of integrity? I know that the Public Procurement Act is not everything. There are other measures that are still coming. Lastly, I want to refer to one or two recommendations that the Commission had made, which we thought would go a long way in minimizing corruption and in making sure that state capture doesn't happen again. The one was the Public Procurement Anti-Corruption Agency that we recommended, which we wanted to be independent of the executive. I see that there is a public procurement office that is being established by the Public Procurement Act, but I see that it's part of the National Treasury.
Yeah.
I don't know whether government had any problem with an entity such as that would be independent of the executive. But one of the things that we had recommended related to our realization that we will never make a significant dent on corruption unless the environment is such that anyone who is thinking of involving themselves in corruption will know that there are very good chances that they will be found out. And that once they are found out, the consequences will be dire. For that reason, we had recommended that this agency should, among others, have inspectorates and inspectorates. We had in mind that this would be, call it an army of inspectors if you want, but we thought that these would be people who throughout the country would be able to come into any government department or organ of state unannounced to come and check what's happening with public procurement matters. These were people who would get tips from government departments and organs of state, because there are always workers, there are always people who don't want corruption, but they don't know what to do without risking losing their jobs. We thought that people in government departments would be able to anonymously alert this agency if there were shenanigans happening. And then those inspectors would come in unannounced and stop shenanigans in their tracks, and they would have enough powers to make sure that they were effective. I hope that it's not too late for government to reconsider that. I see that there is a tribunal established, and we had recommended a certain tribunal, but I think the two are very different.
Yeah.
But I think also a gathering such as this also go back to a very important question that the Commission had to do. Because that question relates to our fight against corruption in state treasury. The Commission said in the early years of state capture, when it was starting, various political parties in Parliament raised the issue and asked that there be public inquiries set up by Parliament to look into those complaints and allegations of the Gupta family exercising undue influence over the head of state. But majority in Parliament would have nothing of that sort done. The question arises, what would happen today if the same thing were to come? Would the fact that the ANC no longer has a majority make a difference? And I've always said, it's not just that it's the ANC only. I've always said there are other parties, political parties, who would do the same, protect their own presidents if they were in power. What do we do about that? When government doesn't respond adequately to this, we must come up with solutions. But we have also recommended a permanent commission that would be able, without fear, favor, or prejudice, to call anybody to appear before it if there are allegations of involvement in corruption and state corruption. And whoever they may be, whether president or minister, and question them in public in full view of everybody, and expose them if they were involved in wrongdoing. Obviously, they will be cleared if they were not involved. Of course, there were complaints that there are a lot of structures that deal with corruption. But the question is, if Parliament sweeps certain matters of corruption and state capture under the carpet, who will raise those matters? The idea of the commission was that that commission would be able to say to whoever had information who did not find joy in Parliament, bring that information here. We have the powers to call whoever and question them in public and let the public decide for themselves. Obviously, if there is evidence, they will have to be charged. It may be that it's not going to be accepted, but the question is, are other structures able to do what the State Capture Commission did? Because that commission is meant to be able to do what the State Capture Commission did. Will other structures who were there when state capture happened, will they act differently and be able to do it? Maybe yes. Thank you very much.
Good morning, colleagues. Ntiane, Soku, Indiana Kazundo. On behalf of the African Procurement Law Units of Stellenbosch University, we want to extend our deepest thanks to Chief Justice Zondo for accepting our invitation to speak at this event. When we conceived of this event 2 years ago, We just wanted to create a space for practitioners, academics, lawyers, and regulators to speak to each other, debate our procurement issues, and by so doing, to contribute to the development and improvement of our procurement system. We never envisaged the kind of interest that existed for this project and the gaps that we would be filling. We never imagined that we would have someone of Chief Justice Zondo's caliber speaking at our event. Chief Justice, we are grateful for the work that you have done for procurement in South Africa. We are grateful that you stand as a symbol of integrity and righteousness in South Africa. And we are grateful that you continue to use your platform to make all our lives better. If I may say this on behalf of everyone who is here, Chief Justice, we are so proud of you. And I am sure that your ancestors are proud of you. Thank you, sir. Nangamso, Uzebenzile, Siyabulela. And sir, if you can accept this on behalf of the African Procurement Law Unit of Stellenbosch University, it is far below the threshold for anything you eat. To be clear, so we're all safe. Thank you very much. And colleagues, if we could please ask you to rise for the Chief Justice to exit. Thank you so much.
Thank you.
Colleagues, will adjourn for a tea break.
Okay, thank you. Oh, right. But you take I was just saying, oh, I didn't say
Yes, ma'am.
You need the same equipment.
It is exactly the same, except for one would give section too shortly. It is exactly the same. those seats to Parliament, one that the National Assembly approved, those presidents, one exception. I see there's a hand raised. You're welcome to unmute. All right, so let me quickly take you through it. I'll just pause on that. So there it is. When you look at the act and you look at the preamble and you look at the objects, you'll see that they're not quite consistent. The act to regulate public entities to frame it within which
So what we're going to do? We look at yes, it's fine. I'm fine with my yeah. So it's fine because I said to
and then to provide information. That is the first key thing. And then when you go down, I'm not going to go through the whole thing. Great to see that it is also in another language what this language is. It's great to see that other it talks about those next thing I go to the there it is. The objects of that 216 and 217. So you can see for the first time the legislation there is reference to 216. That is a very important thing to be very important. The objects of this act are reviewed by Section 2162 to introduce uniform trade rules and standards. That's interesting. The object is to introduce uniform trade rules and standards. So this is immediately saying we are moving into a very, very different world. Different methods, legislation, determining preferences in the framework of all preference policies and visions section 217. That's the key. So this is exactly the same information, the same word as was included okay, so let's jump right there. So there it is. Let's keep going. It's a really exciting time. So before I go down to arrangements, let's just review how it goes. Piece of legislation in 24 months after this act is first published as an act, that's today, the 24th. Right? So I haven't seen it yet, but I've seen this maybe 24 months from now. So it's not the effective date. It's first published as an act. Consult stakeholders in the and within 27 months after this date, so at one point in time, these are really using solution with taking an interim act. When does this activate? The act is called takes effect on a date determined by the city. Like in different provisions of
Use that time to pray. No? If you are to do the answer,
big question is what parts can be fast tracked, inflation fast tracked.
okay, ngathatha ke ngokukosi ba
Different procurement institutions and then repeal different parts of the existing law is the big question. What many are asking, and I was in the discussion what many are asking is chapter 4.
but you are enjoying it.
Fast tracked, we get all the regulations from chapter 4.
Eziningi into azizibalula. As long as you know what you are looking for customers, rather the right team will be successful. Ngathatha ngexesha ezinika
I'm not sure.
ukuthi ngilapha the team must be able to engage all stakeholders. Sizama ubatshintsha ingqondo abangabafuni utshintsha. Remember kaloku abanye nani loo nto
There we are. That's all I really want to just go through. I'd be happy to take any questions that you might have. People ask me which one? I thought that was
What I do with it?
there it is. Act 28.
Yeah, right. Yeah, then I got it.
Yes.
Oh, okay, nothing covers the
Session straight off. Don't know we then start off with a discussion on the first we will remember that challenges. We're going to have the other Peterson. We just need to talk about
Yeah.
that's really this morning. Interesting in session 2 this afternoon, just around capacity building. That will be kicked off by Ronald on this next and then there's a lot of discussion around capacity building and then we will listen to a person from the US who's joining us, Scott Slater. Now, the NRGP is the National Institute of Government Procurement, public body throughout the US, very, very strong program. It's going to be interesting.
I knew it was going to start.
Kudu is going to take us just through the drafting process. Are the methods going to be for preparing categories of preparing institutions? Are the methods going to be categories of procurement? What will the level of detail be? Where will these regulations I wish I could be in that one as well. There's some really good if you not read chapter 4, you'll notice that there's a very important aspect missing in chapter 4. That aspect
I shall say which specific ones I've not taken the full makeup of committees. I'm very glad if there are certain members in red level because we are likely specific bodies in those red roles. There are others I can work with, but look at this. It's like, oh, it's perfect.
That's what we've got. I'm probably going to there it is. Any questions? Brian, you've raised your hand. Go ahead, Brian. Yes, I agree. Yeah.
Peter, I think I'm starting Q2.
Oh, I see.
So you've got
Okay.
time, so if we stop late, we've got a long time for discussion, so we are comfortable with time.
I think that's good.
And your slides are on here.
I can see the slide.
Yes. Oh, did you? Did you copy me on it?
So why do we this is where we took place now? Why do we this is where we took place now?
Perhaps the operative word. Yeah.
They reach the statement the question is this is come out from Treasury.
How are you? Good, good. Good game.
Right. One. Okay, that's a good question.
Okay, my dear.
It's interesting. It is. It is. As the basis they've been categories of areas that's critical because the only assumption is one size fits all. I don't think that's appropriate. So what are we going to do to define there's a category for chemical construction. There's another category for chemical irrigation. Are we going to have separate regulations? Different transfers to what level is it different? And how will the
All good. And the other already on the
I have just been the YouTube and I encourage you all to join that YouTube channel. The sound is better there than to close off this session that you all join that YouTube. If you want, I can keep this open questions if you want, that sort of thing. They live by people respond. So it takes you out to.
Hello.
So I'm Sean.
Okay.
So you got the message.
I thought the message was fine.
And I'm watching stories.
No, good problem.
As soon as I find a stack, I want to stay on the phone so that I lost my mind. No, I'm not. Sorry.
I realized it. I thought that it was the light. I don't mind.
The last Esmeralda.
Colleagues, can we come and take our seats, please? So we're going into the second session. You have it on your program, which is available on the QR code behind your lanyard. So right now we're going to hear from Dr. Peter Volmik. I'm sure many of you know him. He was actually one of Justice Zondo's witnesses. One of the people on the good side. So Dr. Volmik is going to be talking to us about the legal challenges to selection of specific goals under the triple PFA. Dr. Volmik is an advocate, and he's also the leader of the South African Bar Association. And he's one of the most knowledgeable practitioners in public procurement that we have in South Africa. So we're really honored to have you, Peter, and we will have a session and then we'll go to questions after the other speaker. So up to you.
Thank you. Thank you very much, Shobe. For those kind words. I must say I wasn't aware of some of those accreditations bestowed upon me. Thank you so much. The conferences which Shobe and Theo arrange feel like something of a class reunion. Whenever we get together, it's like, oh, nice to see you, and and it's very good to see all of you here today. So my topic that has been assigned to me is the issue of specific goals, and in particular, the kind of legal challenges that one can expect to setting of specific goals. And perhaps it's necessary to say that specific goals have to do with the kind of socio-economic objectives that an organ of state sets for itself in the procurement process. And let us call to mind the words of Deputy Chief Justice Moseneke in a case called Barnard versus South African Police Services, where he said that at the heart of the Constitution lies a transformative mission that hopes to have us reimagine power relations in society. That is what specific goals is about. It's not a technocratic exercise where you just say, okay, how many points am I giving for job creation? How many points are we giving for youth employment? It's about reimagining power relations within society. So that is, I think, a starting point in our discussion. But turning more specifically to the area of legal challenges, I'd like to focus on, well, the intention was to address 4. I may not reach all of it because I know I've got a very strict checklist. But the topics I'd like to speak about are firstly, challenges on legality. Those challenges say your preferential procurement policy is illegal. It contradicts the Triple PFA and it contradicts the BEE Act. So there is a legality challenge, and I'd like for us to unpack. The second challenge relates to procedural fairness. And that speaks to the challenge that when the Triple P is written, when it is issued, no comment is required from anyone. Bidders are not required to give any input. And the challenge is that the procedure that you follow in issuing the preferential procurement policy is procedurally unfair. The third challenge relates to a rationality challenge. That challenge says your preferential procurement or your specific goals don't make sense in the context of the tender. They are irrational, or the way you have assigned points is irrational. So we'll consider some of those if we get to it. And the fourth challenge has to do with a rigidity challenge, or a challenge that says you are so blinkered by your policy, you just believe that you must apply the policy regardless of the factors, circumstances of the transaction before you. In law, it is called fettering, that you have fettered yourself to your policy, or you have tied yourself to your policy. And we will look at that. So let's just make a couple of introductory remarks. The first is that the dust hasn't even settled on the agribusiness decision before organs of state are faced with a new round of challenges related to specific goals. And I suppose it's one of those things which organs of state must just get used to. There's always going to be litigation, there's always going to be challenges, and I think one must just ensure that you don't make it easy on your opponent or the individuals or entities that's taking you to court. There aren't any definitive judgments as yet. There are no review, what you call review judgments. There's no judge that has given a definitive ruling. Most of the rulings that we have so far are in the form of interdict rulings. So various organs of state have been interdicted from proceeding with the implementation of the preferential procurement policy, pending the outcome of a later application for the judicial review and setting aside of the policy. And that's an important distinction because interdicts do nothing other than they just preserve the status quo. So even if you are interdicted from implementing your policy, the judge in all likelihood would have said, this is not a final determination of who's right or wrong here. This is nothing more than preserving the status quo pending the outcome of a later application. It is, of course, your prerogative as an organ of state, and I take it there's many organs of state represented here today, it's your prerogative to determine your own policies. It's not for the minister, it's not for National Treasury, and it is not even for the bidders or even the courts to tell you what should or shouldn't be in your policy. I'm making a general statement. Of course, there are important exceptions to that. And so courts won't likely interfere with your choice of specific goals. But it's important also to say, colleagues, that that doesn't mean that public bodies have carte blanche to write whatever they want in their preferential procurement policies, and that those policies are beyond challenge. The critical principle, of course, is that those policies must always be lawful and they must be rational. I also just want to say that courts have become increasingly critical of bidders who are willing to participate in the bidding process. They get the tender document. They don't raise any complaints about the tender or the tender document. They don't complain about the way you wrote your specific goals. But when they discover that they've lost the tender, then they say, no, remember those specific goals that you wrote about there, those are invalid, or whatever the functionality requirements are vague and unacceptable. And I've picked up from the court rulings that the courts are becoming quite critical about it. I've referred you to some of those judgments on condition that you don't use it against me when we find ourselves on opposite sides of the matter. So the decided cases, you can look at it, these are all relevant. So let's look at the legality challenge, and probably this is the issue that we spend most of our time on if we even get to this. I think it is probably axiomatic to say that when there is non-compliance with statutory requirements, it automatically triggers grounds for review based on unlawfulness. So what are the different challenges? Well, let's start with some easy ones. Non-compliance with Section 2.1 of the PPPA. Section 2.1 says that an organ of state must determine its preferential procurement policy and must implement it within a preference point frame. So, and this may sound like a very basic point, but the determination of and the establishment of a preferential procurement policy is a prerequisite for implementing the framework and allocating preference points. If you don't have a credible policy in place, you cannot assign preference points in a tender. And the Johannesburg High Court said as much in a recent case. They said, absent a preferential procurement policy, an organ of state cannot allocate preference points in a tender. And you need a properly approved policy, not what the court referred to as a hodgepodge of documents, internal directives there written by SEM, or just some document of dubious origin. You need a properly approved policy from whoever the delegated entity is in your organization who approves policies, be it the board, be it the CEO, or whatever the case may be. Of internal documents floating about. The second challenge relates to non-compliance with Regulation 3.1 of the PPPA. Regulation 3.1 says you must do 4 things, And again, this sounds very basic and simple, but believe in me, if you are in the business of reviewing, taking tender awards on judicial reviews, check for these 4 things. It says the tender document must spell out the applicable preference point system. Is it 80-20 or 90-10 or are you unclear or whatever? The specific goal for which a point may be awarded must also be spelled out. The number of points that will be awarded to each goal must be spelled out. How many points are you allocating to each of those goals? And what is the proof of claim? So serious challenges arise, colleagues, when your preference point system is not clearly spelled out in the document. It's either 80-20 or 90-10, or if you are unclear, the regulation says for either 80-20 or 90-10, depending on the value of the lowest acceptable bid. But some organs of state just recite that regulation. So you open the tender and it says, if it is unclear whether the 80-20 or 90-10 preference system applies, an organ of state must then stipulate, and then it gives that whole split. That's not clear. You must actually say, in this tender, it was unclear whether the 80-20 or 90-10 applied, and that is why we invoke that particular regulation. Other areas of contestation is that the specific goals or the number of points per goal are not properly defined. And at least in one case that I've looked at, the preference points don't even add up to 10 or 20. Now, if you have a whole lot of preference points, I mean, specific goals, obviously then they've got to not exceed 10 or 20 points. But sometimes in the rush of getting tender documents out, there isn't sufficient time given for quality checks. But if there's one period, if you forget everything else, just remember the importance of quality checks on documents. For those of you who don't know me, I spent many years, some will say far too many years, in an organ of state. And one thing I've always impressed upon the colleagues there is quality. There's no excuse for a poor quality document that is issued to the market, because it's going to come back and haunt you. So take the time, regardless of who's putting pressure on you to get the document out, take time to check quality. So those are the easy ones, okay? You don't have a policy, or you do have a policy, but the tender document is wishy-washy, it's not so good. I want to get to a more difficult area. And that is the argument that we fail to take into account the BEE Act. No points are given based on the BEE scorecard. And that has become something of a hot potato. And let us collectively think through some of the issues here. So there seems to be two main issues. The one is you have failed to apply the BEE scorecard at all in the allocation of preference points. It's as if there's no BEE when you look at your preference point system. The other is, yes, you have allocated points to the BEE scorecard, but it is inadequate weighting. It's 1 out of 10 points or 2 out of 20 points is given for BEE, and it is very, very light and inadequate. There seems to be 3 main schools of thought about BEE. The one school of thought says only the BEE Act must be applied when we determine your specific goals. It must only be based on BEE. And the adherents of this school of thought would point to the fact that the BEE Act trumps any legislation that conflicts with it. There's a clear trumping provision in the BEE Act. And so the argument is, well, if the BEE Act conflicts with the triple PFAs or whatever, the BEE Act must prevail. The second school of thought, and we'll unpack each of these in a moment, okay? Yeah. But the second school of thought says no, the triple PFA must be applied. The triple PFA excludes the BEE Act from consideration to determine specific goals. But the proposition that I would like to put to you is that the triple PFA and the BEE Act should be read harmoniously, that they are not in conflict with each other. And that would be the third school of thought. I must say, it's a bit of a work in progress. I'm still thinking through that argument. So I may be making some of these things up. But we'll come to the harmonious interpretation argument a little later, okay? So let's look at the first school of thought. Those who say only the BEE Act must be applied and no other. Well, the adherents of that, or the proponents of that argument, rely very heavily on the wording of the BEE Act. They will say, look at section 10(1)(b) of the Act. It says every organ of state must apply any relevant code of good practice issued in terms of the Act in developing and implementing a preferential procurement policy. They would say the legislature could not have been clearer when it says you must take into account the BEE codes when you develop and implement your preferential procurement policy. They further point out that there are provisions in the Act that says that the Minister of Trade, Industry and Competition may exempt organs of state from a requirement to implement the codes, but only if there's objectively verifiable factual circumstances necessitating an exemption. And they will say, good heavens. They will say that absent an exemption, you must apply the BEE. So let me rush along and also just say, of course, there's the trumping provision that I spoke about, section 10(3), that says an enterprise may only be measured for compliance with the requirements of triple BEE in accordance with the code. And those who say only the BEE Act will apply, they even invoke National Treasury, and they say, well, National Treasury's media statement of the 8th of November 2022 confirmed that the triple PFA regulations were not intended to do away with BEE. There is a case which I wish we had more time to discuss, but unfortunately we don't. It's a very recent case called General Counsel of the Bar versus the Minister of Finance, where the court a couple of weeks ago struck down a tender for the establishment of a legal panel for legal services based on non-compliance with the Act. I'll highlight one or two things. I found it quite a shocker, actually, that the court said that the legislation that is referred to in section 2173 of the Constitution, that's where it says legislation must be put in place to create a framework and so on. The judge said that legislation is the BEE Act. Not the triple, well, he didn't say not the triple, okay, but he said that, he said, and it is common cause amongst everyone in this court.
I wanted to clap.
Never mind the judge, because then I'm going to get into trouble. But he said that is the BEE Act. Yet, if you open the BEE Act, it is actually no reference in the preamble that says this is the legislation contemplated in section 2173. But if you look at the triple PFA, it does say that this is the legislation contemplated in 2173. But anyway, who are we? We are mortals. The wisdom or otherwise of the ruling, but there it stands. Remember, it's binding on you. Without saying if you live, yeah, this is a ruling from the Procurement. So you can't even say, no, I disagree. And the judge said that the BE Act and the codes cover the field insofar as preference points are concerned. In other words, there's no other things to give preference points. It covers the field. In fairness, he was simply saying this is an argument by the General Counsel of the Bar, and he thought it was a lucid argument. But there was no exploration of the interplay between the Triple PFA and the BE Act. Now I must talk really fast because I think I've got about 5 or so minutes remaining. A further argument in support of the notion that only the BEE Act must be applied, not these other specific goals, is an argument based on unreasonableness. And the argument goes something like this. Bidders and companies at large have invested a huge amount of money in improving their BEE scorecard.
Yeah.
And now they hear that all of that effort, all of that money has fallen by the wayside because the preference points is now based on black ownership. And the argument that has been advanced is that this shifts the goalpost. Now that you've achieved the goalpost shift. Also, a related argument is that companies who fall in this non-designated group, if you like, they have got no chance of competing on the preference point system because they know they're going to lose badly there. Their only chance of winning is to offer unsustainably low prices. And that defeats the objectives of cost effectiveness and fairness. And they also say this is nothing other than pre-qualification through the back door. You may not be calling it pre-qualification, but the weighting that you put on black ownership effectively amounts to pre-qualification through the back door. And I wish I had time to deal with each of these, but possibly on another occasion we can unpack it. And they say what this amounts to is importing narrow-based BEE in contravention of the Act. Now, quickly, the second school of thought that says, no, the Triple PFA applies, not the BEE Act. This points to the fact that Section 2(1)(b) of the Triple PFA says that preference points must be based on race, gender, and disability, not BEE level. BEE levels, or so goes the argument, is not based solely on the grounds of race, gender, or disability, but there are 5 distinct pillars: ownership, management control, skills, you know all of them, ESD, and so on and so forth. And the Triple PFA says you have to give preference points based on race, gender, and disability. The argument is that organs of state must be allowed to allocate points for the specific goals that they want to advance. And they want to advance job creation, they want to advance rural development, they may want, there's a range of objectives, but you can't straitjacket organs of state to apply only the BEE. There is also an argument that that black ownership is actually a better indicator of the transfer of economic benefits than BEE. The argument being that you can have a fantastic BEE score, but very poor black ownership. And the argument is black ownership is a far better indicator of the transfer of economic benefits to black people than a kind of a generic BEE scorecard. There is also the argument that National Treasury's implementation guide says that you cannot use BEE as a specific goal. For the sake of time, You can look there at the implementation guide. The Treasury says, no, it's actually one of the common errors is that you use BEE and you use other specific goals. So that is the argument. But, and with this, Madam Chair, I don't promise, I will endeavor to wrap up. Bearing in mind that I'm about 25%. Okay, but seriously, the third school of thought is that legislation should not be read oppositionally. There's a principle of interpretation that Parliament is presumed to have in mind existing legislation when it passes new legislation. And it actually frames this new legislation in the BEE Act with reference to the existing legislation. There is a principle in our law that says statutes that relate to the same subject matter should be read together because they form part of a single harmonious legal system. So when Parliament wrote the BEE Act in 2003, it wasn't like unaware that they had just written the PFA 3 years prior to that. Yes, there is a trumping provision in the BEE Act, but that only kicks in when there is an irreconcilable conflict. And the argument would be, and the one that I would like to suggest, is that there is no irreconcilable conflict. And bear in mind that in support of a harmonious approach, and harmonious approach means you can give points for triple BEE, but also for other specific codes. In the case of AXA versus Imperial, and many of you will be familiar with this judgment from the SCA, there the SCA said that both the triple PFA and the BEE Act constitute the legislative scheme that was spoken about in 2173. Unlike this recent ruling where they said there's only the BEE Act. The Supreme Court of Appeal, which is the second highest body, said no, both acts constitute the legislative scheme, and what this would mean is that organs of state must implement their preferential procurement policies with adherence to both pieces of legislation. The BEE Act is not some kind of poor cousin of the triple PFA. It must be taken seriously. It must be given the weight that is necessary. On another occasion, we can speak about some of the challenges with harmoniously double counting and all of these things. But let me stop there before I get booted off the stage. And Madam Chair, thank you, colleagues.
Thank you so much, Dr. Wing. You get exactly to time. Thank you so much for doing that.
Surprise, surprise.
Okay, so our next speaker is Ms. Leander Peterson. She is the Director of Supply Chain Management in the SCM Policy and Legal Units of the Office of the Chief Procurement Officer of National Treasury, where she is primarily responsible for designing and implementing the legal framework for public procurement in South Africa. So we are extremely fortunate to have Leander with us. Leander, where are you? Okay, she's on the way. Right. Oh, she's got her laptop, okay. It's on here, yes. This one, yes. Thank you so much. Thank you.
Good morning, everybody. I think all protocol observed. I'm not sure who's in the audience, but it's lovely to see you all. My name is Leander, as you heard. I am from the National Treasury. I'm also joined by my colleagues, Kiwenge Sihle, Mashavani also at the back. Sihle has been also very involved with the rollout of the preferential procurement regulations of 2022, so I'm not alone. And then we have Mr. Matibula, William Matibula in the audience as well. His claim to fame, apart from many other things, is that he was the first witness in the Zondo Commission. So I think that's quite a So thank you, colleagues. So let's get on with the thing. Peter, I enjoyed your presentation, I must say. I'm looking forward to the discussions. I think it's going to be quite interesting. So although the program says, I think the title says the use of BEE status level under the preferential procurement regulations, my heading is the use of specific goals for claiming preference points under the PPR 2022. Now, the reason I'm doing that is not that we're not going to talk about BEE status, but because I'm from National Treasury, I need to come from the approach of the legislation that the Minister of Finance, that falls under the auspices of the Minister of Finance. And that's the approach, in any case, that we took in revising the PPR. So, but we are going to talk about the issue of BEE. So we're going to do a quick recap. I think everybody in the audience is aware of how we got to where we are, but sometimes it's just important that, with all the noise, that we sometimes just get on the same page a little bit. And then we'll look at the overview of the provisions that relate to specific goals, and then how we use specific goals to claim points. The fact that the BEE is a legislative policy of government, so I think it mustn't be, nobody must misunderstand the position of Treasury. We still stand by the fact that the BEE is a legislative policy of government, and indeed the triple PFA and the triple BEE can coexist. Okay, and then just lastly, then we're just looking at preferential procurement, closer zooming in under the triple PFA vis-a-vis the Constitution. Okay, so a quick recap, as I said, regulations 3, 4, and 9 of the preferential procurement regulations of 2017 were successfully challenged through a court process. Now, we know that this challenge happened Afri Business, now Sakaleka, took on the Minister of Finance in the High Court in Pretoria, and Judge Francis found in favor of the Minister of Finance. He found that the regulations were rational and that they achieved what they were intended to achieve. Afri Business then appealed, or challenged this decision on appeal. Initially, Judge Francis didn't grant that appeal, but it was taken to the Supreme Court of Appeal. They granted that, the appeal, and they upheld it. But what they said was, so the analysis of the SCA, if you look at paragraph 40 of that judgment, says the SCA held that the Minister's promulgation of regulations 3B, 4, and 9 was unlawful. Then they said he acted outside his powers in terms of Section 5 of the Preferential Procurement Policy Framework Act. Now, sometimes they call it the Framework Act, sometimes they refer to it as the Procurement Act, but both of these are the triple PFA. Okay. So, and then the order was, it is declared that the Preferential Procurement Regulations of 2017 are inconsistent with the triple PFA, with the Act itself, and are invalid. But then they suspended that declaration of invalidity for a period of 12 months. And of course, the Minister then challenged that decision, and he appealed to the Constitutional Court, and the Constitutional Court found, although they also at the end, the ultimate decision was that the regulations are invalid, pardon me, they had different reasons to what was stated in the SCA. So what the Constitutional Court said was that regulations 4 and 9 are an important part of achieving Section 2172 of the Constitution. So they were not saying, they're saying they can understand why the Minister did what he did, and in fact, it was a good thing. But the bottom line, as I said, the difference between the majority judgment and the minority judgment, which incidentally was a 4-5 split, was that it was not necessary or expedient for the minister to prescribe those regulations, those impudent regulations. They said essentially, if you can use colloquial terms, minister, stay in your lane. Okay? They said it's going too far. Because section 2.1 of the PPPA vested power to determine, and Peter has talked to that just now in his presentation, the power to determine a preferential procurement policy was vested with the organ of state, not with the minister. And so when the minister developed and prescribed Regulation 4 and 9, what he did was effectively amounting to determination of policy. And so, that was, they said, they then declared the entire set of regulations invalid. And again, so when the minister appealed, that 12 months of the SCA was interrupted, was sort of stopped, and after the judgment of the Constitutional Court, that 12 months was then continued. So then, so with that in mind, the minister now had to act quickly and start working on developing this revised set of regulations. And now, as a point of departure,
Sean.
apologies. I'm actually just come back from a bed of illness, but I was supposed to be in hospital today, just a quick aside. But because I promised here that I'd be here, I had to keep Thank you for that. So what we then said is, let's look at what is the rationale of the Constitutional Court, so that when the minister develops these regulations, he must do so taking into account what the highest court of the land actually feels about, and what the highest court of the land is actually stating about preferential procurement. So very quickly, some principles that were confirmed by that judgment. So if we look at paragraph 14, it says, and this talks to what Peter said as well earlier on, it says section 2172 of the Constitution allows organs of states to implement a procurement policy, right? That provides for categories of preference, the allocation of contracts, provides for protection and advancement of persons and categories of persons, etc. And then it says section 2173 makes it clear, however, that that national legislation must prescribe the framework in which section 2172, those policies must be implemented. And then it says that legislation is the Procurement Act. So that's very interesting. So we get the High Court judgment that Peter spoke to, Gauteng. We get the SCA judgment that talks about PPPA and BBBEE. Then we get the Concord that says that the PPPA is that national legislation. Now, you might say, but yeah, you're quoting from paragraph 40, and that is actually a paragraph from the minority judgment. But I'm happy to tell you that in paragraph 101, the majority judgment confirms the same thing. And in fact, what they also go on to say, sorry, it's bad when you don't have your notes, but so what the majority judgment said is that actually we agree, the minority judges and ourselves, that judgment, we agree on all issues. And then they say, that's in paragraph 100. And then they say in 10, then they go on to say, in fact, we must, because they say we do not disagree on the transformative imperatives. They say we cannot, we must agree on that. And we do. But we say that, but then they're going to say, we will go on to say what we do disagree about, the one issue. And that was about the interpretation of necessary or expedient. And in 101, they actually confirm, which will be on the next slide, that indeed, so paragraph 40 says that, minority judgment. Paragraph 101, the majority judgment, also says that the PPPA is that national legislation referred to in section 2173. So, what does Judge Davis say? Judge for yourselves. Okay. And then, so in paragraph 41, So I'm just building up people, I'm telling a story quickly, and I promise I will keep within my time frame. Paragraph 41 says, as we know, regulations are subordinate legislation, and it is prime law that subordinate legislation must be created within the limits of the empowering legislation or the empowering statute. If they are not, the exercise of the power is unlawful and may be set aside like an unlawful act of any other functionary who has acted outside the powers conferred upon her by the legislation. So again, what we take from there as well, that when we're looking at regulations, because they are regulations under this empowering statute, they cannot go outside of that statute, essentially. That's the principle. Okay, and there's the paragraph 101 that I was just telling you about, where again they confirm that the Procurement Act is that 2173 legislation. And they also got, and again, the principle is that it's within the bounds set by the legal framework that the exercise of public power must happen. So including any guidance that should be given. And then paragraph 103, again, essentially reiterating what was said in paragraph 41. Ordinarily, the purpose served by regulations is to make an act of parliament work. So the principle again, so remember I'm saying all these things to show you how the development and the thinking around how the PPR 2022 came about. So in essence then, the PPR sought to give effect to the triple PFA, to make the triple PFA work, and not to give effect to provisions of another piece of legislation, in this case the triple BEE. But don't get me wrong, we're coming there, right? So this is the principle that I want to leave you with. So then, since that is the case, since the regulations are under the triple PFA, let's turn to what does the triple PFA state, okay? So in section 21B of the triple PFA, it says, it provides that on the 90-10 approach, a maximum of 10 points may be allocated, right? We all know that. But it says, for specific goals as contemplated in paragraph D. And then section 21B2 says, provided for the 80-10 approach, 80-20 approach, a maximum of 20 points may be allocated for specific goals as contemplated in paragraph D. And then 21D then is this 21D is this paragraph D that's being referred to. So 21D then sets out the specific goals that an organized state may include in their preferential procurement policy. And it says the specific goals may include, and I know the may is often what people focus on and say, but if it's may, doesn't it mean then that it's discretionary and that you can go outside of that? And so it says the specific goals may include contracting with persons or categories of persons disadvantaged by unjust discrimination, Sorry, I'm not glossing over it, I'm just trying to be mindful of time. And then implementing the programs of the RDP. So again, just to quickly take a step back, we need to then remember that the freedom that's conferred on organs of state to implement preferential procurement policies is constrained by section 2173. Because remember, 2173 says national legislation must prescribe that framework within which these policies that organs of state are implementing must be implemented. Okay, so, and then this framework then is contained in the Procurement Act. So so if you follow the logic or the rationale, it then means the specific goals that an organized state must adopt in its policies are limited to those contained or articulated in the Procurement Act. And then although it says 21D states specific goals may include what is provided for, the may in the National Treasury approach is that, and I must say, the eyes of the law are human eyes. So even judges are people, so they have their views. Okay? They try to follow what the law says, but essentially we've all seen that there's issues around interpretation. But the interpretation is that because 21B, 1 and 2 refers to the specific goals as contemplated in 2.1d. That may is not intended to suggest that what is provided for in 2.1d is discretionary and may be departed from. It limits the specific goals to what is contemplated there. The may is just saying that of those goals that are there, the organ of state has the latitude and the freedom to choose what goals they wish to use. But again, given the choice of goals, and this is what we always say to people, even on the road shows, it shouldn't be an arbitrary thumbs-up kind of exercise. You need to know the market within which you operate. You need to know the suppliers. You need to know what your strategic objective is of that organization that you work for, what the mandate is, and so that your goals have a rational link to what you're trying to achieve. Okay, so, and then and if we look further, if we look at 2.1e of the Procurement Act, it says an organ of state must, in the invitation to submit a tender, clearly specify the specific goals for which a point may be awarded. And so this is where we get to the crux and the fundamental difference and the school of thought that comes from where we're sitting, that utilizing the BE status level, now listen, the status level of contributor, not talking about looking at the BE codes of good practice, saying looking at the BE status level of contributor. So that means that's something that looks at the elements, rolls it up into one, gives you a point. Then the organ of state takes that point and allocates, or takes that level and allocates points, right? We're saying doing that does not provide the organ of state with an opportunity to choose specific goals. It limits the organ of state from determining those specific goals in their own tenders, because it means every time, no matter what your objective is of the organization, no matter whether or not you want to try and look at increasing the domestic manufacturing capacity, so you want to give more points for your, and I use the term loosely, localization, in terms of South African-made products, for example, you don't have the opportunity to do that, because each and every time you just use the BE status level, particularly if you're using it exclusively. Okay, so just to reiterate what I said there, so from where we stand, there's no legal basis for regulations that are developed under the Procurement Act, that's the PPPA, to incorporate provisions that give effect to another act in the way that people wanted to do. By saying no matter what the Procurement Act says, we must use the status level of contributor, and that's that. And we say there's no legal basis to do that. And in fact, even the points that institutions use now, you find some, just put that table in the policy, and we say even there, I mean, the basis that they're doing it is based on repealed regulations. But hey, they put it in the policy, maybe there's a rational link for doing that, but we say from where we're sitting, that really looks like more of a lazy attempt. And I say this respectfully, but it's not applying your mind, the institutions are not applying their minds to the objectives that they need to achieve. Okay, don't crucify me. You all know that I see the gentleman has a hand up. I'm sure there's going to be a discussion after this. Yes, I believe so. So, and if you look at the implementation of the RDP, that in itself encompasses a wide array of goals, which, for example, I'm just throwing out some examples here, creating jobs that are sustainable, increasing the ability of the economy to absorb new job seekers, for example, in both the formal and less formal sectors, integrating into the world economy, utilizing the growing home base in a manner that sustains a viable and efficient domestic manufacturing capacity, increasing the country's potential to export manufactured products, ensuring that no one suffers discrimination in hiring, promoting, training, etc. So I'm saying when we look at the implementation of these goals under 2.1d of the PPPA, we've got a whole host of things that we can seek to achieve. And the nice thing is, you're not forced to use the same goals in every tender. We have the flexibility, even in that same institution, to use different goals for different tenders, based on what that tender is about. Okay, so for us, we're saying again, that in implementing what is provided for in section 2.1d, organs of state would be providing for the application of the BEE elements of the triple BEE codes of good practice. So for us, that's where you see the harmonization. So we're not throwing out triple BEE, but we're saying, if you are looking at persons historically disadvantaged on the basis of race, gender, or disability, those are elements in the scorecard, in the codes of good practice. So when you're doing that, you are taking into account what the triple BEE Act is saying. But using the BEE status level of contributor from where we sit cannot be equated with BEE codes of good practice referred to in section 2.1b. Still 10 minutes. Okay, I'm almost done. Thanks. So what we're saying, just want to quickly, I was actually thinking that I was behind, so that's great, I'm almost done. And that's what I want to say on that point, for example, of the domestic manufacturing base. And we know, and this is the other thing, government, we need to remember, government has a number of competing objectives. So when we have this opportunity to do something that can actually promote some of those objectives, procurement, remember, is that lever that we're supposed to use. So we should not want to, and I know, for example, and maybe let me move on to that. I know that one of the, I think in the court cases that Peter cited was about people saying that we've worked hard to get our, to get to this level, this BEE status level, we've paid a lot of money, etc. But I think in the broader scheme of things, we also need to look at what are we seeking to achieve by these different pieces of legislation. So before I come to my conclusion and to what we're saying about that again, let me just qualify what I was saying earlier, that BEE is a legislative policy of government. If we look at the definition of what broad-based Black economic empowerment is, it says, means the viable economic empowerment of all Black people, in particular women, workers, youth, people with disabilities, and people living in rural areas, through diverse but integrated socioeconomic strategies that include, but are not limited to, increasing the number of Black people that manage, own, and control enterprises and productive assets. The broad-based Black Economic Empowerment Act facilitating ownership, management of enterprises, and productive assets by communities, workers, cooperatives, and other collective enterprises. C, human resource and skill development, achieving equitable representation of all occupational categories and levels in the workforce, preferential procurement from enterprises that are owned or managed by Black people, and investment in the enterprises that are owned or managed by Black people. So by its own definition, broad-based Black Economic Empowerment Act is broader than preferential procurement. So the use of specific goals will contribute to the achievement of the aims of broad-based Black economic empowerment, not vice versa, though. Because the more opportunities are afforded to historically disadvantaged persons, the more we can deal with the injustices of the past. So I'm going to turn back, in conclusion, to what the Constitutional Court said and how it was instructive. That decision was instructive in confirming the line of sight between the triple PFA and the Constitution. Okay, now we will be the first to admit as Treasury that the triple PFA is limited in the way in which it was dealing with Section 2172 and 2 of the Constitution, in that it just limited us to a point system. But when we look at, but at least the focus by having these different specific goals was on previously disadvantaged individuals and vulnerable groups. So if we look at paragraph 60 again of what these transformative measures that the majority judgment was also saying and agreeing with the minority judgment on. They said 2172 and 3 of the Constitution were drafted into the Constitution in acknowledgement of South Africa's unfortunate history, which amongst others excluded Black people from access to productive economic assets. These subsections and the legislation envisaged under 2173 aim to redress that history of economic exclusion. Section 2172, therefore, permits preferential procurement notwithstanding the principles in Section 2171. It must be emphasized that the scheme of Section 217 of the Constitution, and this is quite interesting, and this is said by the Court, the Constitutional Court, the highest court in the land, that the section authorizes the state to, in certain circumstances, exclude from the award of contracts persons who did not suffer unfair discrimination under apartheid in favor of those who were discriminated against. This exclusion constitutes an effective tool in the hands of the state to redress the injustices of the past regime and to heal the hurt and suffering visited by that order of the black majority in this country. So when we talk about the fact that yes, we have paid a lot for our BE certificates and so on, that doesn't necessarily mean it's going to go to waste. Because remember, BE is broader than preferential procurement. It's also used in other transactions like licensing, etc. But we cannot then be afraid to apply the law by virtue of the fact that there might be some people who feel that they have to pay a lot. You know, things happen. The nice thing is DTIC is also utilizing CIPC for smaller businesses so that they can get certificates that way. They've also introduced issues like affidavits, sworn affidavits. So it's not the end of the world. And I say that really respectfully. But I'm saying that there are there's broader objectives that the Constitution talks to, that the legislation that has been developed must follow. And then paragraph 69 says, what is worse, the scoring method in section 2 restricts the purposes of preference, protection, and advancement envisaged in section 2172 to only 20%. That's if you're using your 80-20, even less if you're using your 90-10 in each tender. So they're saying logically, this means that those who benefited under apartheid still enjoy an advantage of 80% of the scoring system for tenders, despite the intended objectives of protecting the previously disadvantaged. So, and this is what the Apex Court says, this constitutes no protection at all, and in fact is an interpretation contrary to the Constitution. So, lastly, this is my last slide. So when we then assess the statistics relating to tenders that were awarded on the basis of BE status level of contributor, it became apparent that this was not achieving what it wanted to, was not effectively leveling the playing field as envisaged, right? And in fact, what had happened often was that you'd even find well-established white-owned companies who would come out at a level 1, their black counterparts would come out at a level 7 and would end up losing the tender. So, and that's why we're saying, if the PPPA has a line of sight to the Constitution, but it's not actually protecting or advancing the persons it was intended to do, then surely we need to look back and say, guys, is this what was the intention? Okay, so I just want to say, so over and above the legal basis that we have in terms of saying why we need to use specific goals, there's also then the fact that by utilizing and I'm not saying utilizing BE, I'm saying utilizing the BE status level of contributor resulted in a dilution of the efforts of what the PPPA, which already was diluted by just a point system, was seeking to achieve. And lastly, so in the media release issued on the 9th of November by the BE Commission, subsequent to the gazetting of the PPR 2022, the BE Commission had the following to say. They said, thus, in implementing preferential procurement, an organ of state or public entity will have to comply with both the requirements of the 2022 PPPA regulations and the BBBEE Act, which means that the BBBE criteria will still be part of the 20 and 10 points under the 80-20 and 90-10 procurement system, which currently empowers organs of state and public entities to set a goal, right? Which in this regard includes promoting access by Black people and Black enterprises to procurement opportunities in organs of state and public entities. So the above statement aligns with the position that we submitted earlier, that in implementing what is provided for in section 2.1d of the concept of the PPPA, organs of state would be provided for application of elements of the BBBE Codes of Good Practice, without undermining the provisions of the PPPA, and still be complying with section 10.1b. That is our submission. But thank you for your time.
Thank you so much, Nyanda and Dr. Baldwin, for those. I think to sum up the session, we would say to be or not to be. That is the question. So we'll go into our discussions and question and answer. So we have 3 mics. I think can Chad have a mic as well to help us? I'm just abusing my position as the lecturer. So we will take questions, maybe 3 or 4 questions at a time, and then you can direct them to our panelists or to Professor Keynote, maybe, but not to me. and then we'll take this up till lunchtime. So over to you. Okay.
So I'm going to abuse my position as organizer to put the first question, and then we'll go to the floor. So thanks to both. Where's the Anya now disappear to? Okay, good. Can't disappear. I've got a million things that I want to ask you, but I'm going to restrict myself to 2. 1 question and 1 comment. Can I talk while you're walking? Good. So my question is it fair to say that National Treasury has changed its position between its opposition to the agribusiness application and the 2022 regulations? And the reason why I ask that is that it will help a lot, at least for me, in wrapping my head around what is going on in this space at the moment. Because National Treasury opposed the agribusiness application, right? So they resisted the argument that those regulations were unlawful, all the way. So, in other words, National Treasury took the position in the agribusiness case that those regulations are good. Those regulations, the 2017 regulations, used exclusively BE status for the 10 and 20 volts. The case in the end in the ECC turned on section 5.1, necessary and expedient. But what I'm hearing you say now is that National Treasury's position now is, regardless of 5.1, forget about 5.1, under 2.1d, what the 2017 regulations did was unlawful, because it is not aligned. Regulations for exclusive use of the status is not aligned with your now reason of 2.1. And that's fine. I mean, I'm not critiquing, I'm just asking. Because if National Treasury says to us, yes, we've come to a different view. After having gone through this thing, we've now formed a different opinion. This is how we now read it. We change it. I think it will help a lot of us a lot. Because then we'll say, oh, well, then we understand. There's not a conflict here, it's just a change of view. So that's my question. My very brief comment, and this is perhaps more kind of paving the way to what we want to talk about tomorrow, is that this issue, this session, of course, has got both short and long-term implications, and they're very different. The short-term implications is really the question whether the bulk of procurement in this country is going to be irregular from January last year, depending on which court arrives at a conclusion in these parties first. And heaven forbid that it will be, it's all irregular. That's the immediate, and I know a lot of organs of state that's very worried now about going out on their policies because they don't know where they're going to land. So that's the immediate problem. But there's also, of course, a long-term question. And that's the question, what does this tell us? Not the specifics about the PPPA, but the 217 analysis behind this. What does that tell us about the new Act, Chapter 4? What we're going to put in regulations under the new Act? Because, I mean, surely we don't want to end up here again. And I think that's something that all of us... I'm done, almost. Sorry, sir. I'm doing what I always said people should not do. I think that is why, as a community, we need to think about 217 and the interpretation as a point going forward. Sorry, sir. Done.
Seeing that it was condoned, the abuse of the mic is in the prerogative of whoever holds it. I'm also going to take the opportunity to ask for a show of hands. Please, 1 minute. Anything longer is irrelevant and I will snatch the mic away. Don't make me now appear the rude person. Just honor the obligation of holding the mic for 60 seconds. Shophead, who has... Okay. Can we take 3 at a time so that we can at least just get the questions coming through? Chad, who are you going to?
Thank you for the opportunity. I'll try to be as quick as possible.
And one more here. So whoever has a mic, please, when one is done, stand up and talk.
All right. Again, to National Treasury, I think it's a huge concern, just to add to what the professor is saying. We try to look, you want us to have a different interpretation of the word may, to be limiting. And anywhere you can go, you can never find it to be as limiting as we are in trouble today. HSA thinks we should not use BBE or harmonize the two legislation. While BBE Act is a current legislation that has been approved, and if you don't comply with it, you are still illegal. You want us to say we should not use it based on the language that we've used in the implementation guides. And the biggest concern is that you continue to many of us do pre-qualification. That leaves no room for us to set a policy. We can't set a policy because we are told what to do. We are more prescriptive than putting a framework together. So we are worried about how the regulations are going to be. Are we going to be in a stage where we're going to conform to section 2172, where we put our policies in place? For instance, sorry, just one. For instance, Transnet, right? We deal with OEX. When you say we must set aside, how are we going to do that? When you say we must do a pre-qualification, how are we going to do that in a situation where we're dealing with OEX? So just think about how the wording that we use, how prescriptive.
Thank you very much. Thank you very much. Next question, please.
Thank you. My question is directed to Peter. Earlier on, you mentioned the GCP decision, and I think you're referring to paragraph 71. My question would be, how do you harmonize the procurement process that was followed in the RT19/2024 versus the referral advocates rules as the bar members which you belong to, which you know very well, ethically and otherwise, the what is this thing called? I'm sorry, I don't know this one. The PPFA, including the BEEF. How do you harmonize those three? Thank you.
Yeah, I'll be quick. Council, I was interested to see the slide on beneficial ownership, but I understand you're running out of time. But I think obviously beneficial ownership is not something that is currently being considered within procurement circles in the way that is being considered in other corporate services. Right? So to what extent is beneficial ownership moving forward, because it's going to shift the dial, going to be important specifically for procurement practitioners, so as to ensure that they can ensure that there's mass participation, they can ensure that there is competitiveness, but also to ensure that there's no collusive bidding that's happening. Because what we've seen that if we dig deeper into beneficial ownership information, you might find that there are instances of double dipping. So that's our supervision at that.
Thank you. We'll go to Leander and then Peter Bowman to answer those questions.
Thank you, colleagues, and thank you to those two colleagues who also directed questions to Peter. I was getting worried for a moment if we scared. Sergio is not here. Okay. maybe just quickly talking to his comments around the implications of this, and even in terms of Chapter 4. I think what we will be doing, and again, I just want to also take the liberty through you, Chief, to, if my colleagues want to come in, to please give them a chance to do so, because I'm not alone, so I don't want to hog the stage. But there is a process and an approach that we intend taking in terms of developing the regulations under the bill. So it's not under the Act now. It's not something that's going to happen in a corner. There is a rigorous stakeholder consultation approach that is being developed and which will take place. But also we will have webinars that will take colleagues through the process of our thinking around what led to particularly Chapter 4 looking the way it looks, and how it's intended to actually operate. Okay, so maybe I can just answer a couple of questions, and then my colleague, I think we have a mic, Cecily, don't have a mic? They'll give you a mic when we, yeah. Okay, so, and Mr. Matibula. So here's a question around, is it fair to say that the position has changed? Now, it's a bit of a tricky one in the sense that you will remember that there was a cabinet resolution at some point that spoke about aligning triple BEE and triple PFA and so on. And unfortunately, when that happened, the easiest way to do that was by bringing in a BEE scorecard. And so you will notice that in the task team's report, even at the stage of the Agribusiness Challenge, the task team was consistent in saying, in raising the issue of using triple BEE, even at that stage. And that is why, when the 2017 regulations were developed, the link, there was the way in which we looked at harmonizing what the triple BEE Act is saying and what the triple PFA Act is saying, was by saying, okay, in the BEE legislation, it talks about qualification criteria. So what prevents us then, while still having the point system, and like we said, we had concerns about the point system using triple BEE, but that was water under the bridge. It was there now, and there was it was based on largely on a cabinet decision, as I understand it, because it was before my time. But we then, as a task team, indicated that that in itself doesn't go far enough. Like what the Concord has said, it's ineffective as a tool for redressing and looking at what 2172 is intended to do. But if we look at qualification criteria and linking it, you'll see the constructs in those qualification criteria were linked to BEE constructs, triple BEE constructs. We didn't use concepts like small businesses. We spoke about EMEs and QSEs. We spoke about BEE status level of contributor as a qualification criteria. And then we looked at going a bit further and saying, okay, let's, at least if we cannot set aside altogether, let's have a subcontracting provision. But all of those, if you look at who those designated groups were, they were BEE constructs. So that was the way in which that marriage was intended, was operating at that time, which again was then confirmed that it was achieving what 2172 was intending, but it wasn't the minister's place. So I don't know if I can answer that by saying the position changed, but I think it was it was something that had happened, but there was recognition that it was ineffective. Even at that time, the task team, and that is why even Judge Francis felt that 4 and 9 were actually relevant regulations in making triple PFA and strengthening the objective of triple PFA. Here you probably missed out, but we can chat. Okay.
It's on YouTube. It's on YouTube. You can have a look.
Oh, dear. Oops. And then the gentleman from Transnet, about, I assume you're from Transnet, so, the huge concern around triple BEE being the current legislation. Again, and I'm pleased and I'm glad it's on YouTube, because then I think, on the one hand, I'm glad, that I can't be misquoted. I say that BEE is the legislative policy of government and it should be used, but using triple BEE status level of contributor does not equate to using or applying the codes of good practice. So, I spent a bit of time sort of going into that. Maybe we can chat again if you're still unclear, but okay. And issues around OEMs and all of that. I see people make some comments about the bill creating a problem. It's not going to happen. I think let's not put the cart before the horse. Like I said, there will be a consultative process. All those concerns from the different organs of state, you will all be involved, well, representatives at least, will be involved in developing and in having these consultations around shaping what the regulations should look like. Okay, so it's not going to be something where there's a concern around this, because sometimes, remember, we have your civil society that talks about access to information, and that they generally would like to have everything maybe out in the open, and I'm just paraphrasing, I'm not saying, I'm exaggerating that. But you have your Department of Defense, for example, might want things a bit more closed. So we're saying, let's hear from some of these, from these groups, and let's see how do we take that forward. Doesn't mean we must have a differentiated approach in certain instances. Do we have a meeting of the minds so that we reach a level where everybody's happy? So those are the kinds of things we want to look at. Okay? So don't panic around what the act is now saying and what the regulation will look like. We will all be part of that process. Thank you.
Yes, I think there were a couple of issues. Let me just say, first of all, thanks to Leandra for that presentation. As always, very interesting. The Constitutional Court did say that the triple PFA is the legislation contemplated in 2173. But I don't think it was intended to give a complete answer to the question that we are grappling with here. And that is, should the triple PFA and the BEE Act be seen together as the legislation that is spoken about in 2173? So as much as I think the Agribusiness decision does point us in the right direction, and certainly away from the GCB decision that says it's only the BEE Act, I don't think it is a complete answer to a harmonized reading of the two pieces of legislation. Insofar as the argument that you can actually take or apply BEE as long as you don't apply the status level of contributor, I think we need to engage with that possibly a little bit more.
Yeah.
Because if I understand the BEE Act, it doesn't say, well, as long as you use race or so, as long as you refer generally to things like gender and race, then you are okay. The wording of the Act is that every organ of state and public entity must apply any relevant code of good practice issued in terms of the Act in doing various things listed in subparagraphs A to E. That suggests, at least in me, colleagues, on a purposive reading of the Act, that it wasn't intended that the broad principles of advancing people on the grounds of race and gender, as long as you refer to that gender, you actually satisfy the requirements of the Act. I think what was intended is that you've got to apply the codes of good practice, which in turn makes reference to the various status levels of contributors. So that is perhaps the one point where I may have a slight deviation from what was presented. As far as, I think there was a question about the use of the word may and whether the requirements in section, or the issues listed in 217B, are those exclusive, or can it actually look at other aspects as well? Well, it's critical that you read section 2 of the PFA in light of the protective purpose of the Constitution being 217. The Constitution says you can take measures to promote people who have suffered discrimination. The triple PFA lists race, gender, and disability. But there may be other grounds where you can say that, but this group has also suffered discrimination. It may not fall neatly into race, gender, and discrimination, but I am in keeping with the protective purpose of the Constitution by including these people, even if they are not specifically mentioned in 217D. Let's think of an example.
Small businesses.
Small businesses. It could, well, of course, they may be covered by the RDP. Yes. Okay, let's think of something that's not covered by the RDP. Let's say locality is also RDP. Okay. No more suggestions. But let's say language. Someone says, yes, I am a speaker of an indigenous language, and I cannot engage properly with these documents that's issued in English, and it's been a historical legacy that indigenous language speakers have been discriminated against. I can't see that you'd be acting outside the protective and the promotional purpose behind section 2172. If you also include a provision to promote people based on whatever the historical discrimination may be. Then there was some question about I think there was the GCB's case and the fact that the tender there sought to get referral advocates to sign a contract with the National Treasury, some sort of transversal contract. And where the area where I agree with the judge is that he said, but you are governed by the Legal Practice Act and the codes of ethics associated with that, which actually prevents you from concluding contracts with. You are a referral advocate. You take briefs as they come in. You cannot commit to a predetermined contract with any particular organ of state. And there the court actually felt that you'd be acting in breach of the code of ethics. There was a question about beneficial ownership, which I didn't quite get. Maybe.
So for me, it's to say that obviously there's an importance in using beneficial ownership information. It's something that's not being currently done as a matter of practice now. Because ultimate beneficial ownership shows you, for instance, who else has got an interest in a particular entity that is bidding. And most of the time, if you
other than the
directors, exactly. So sometimes you might find that you might use that information to ensure there's no collusive bidding, because some individuals are sitting at the top and are submitting 5 companies, and they've got an interest in all 5, which then means that it circumvents the aspects of mass participation and the competitive nature thereof, but also any elements of fraud. So some people see, are we ready as a country to elevate beneficial ownership information to the next level? Or because we've got a new act, which is still focused on this?
Well, I think the question has to be, who are the real owners of this? So, and it's an important anti-fronting mechanism to adopt as well, to say, yes, I see who are the formal shareholders, but who are the beneficial owners? Who is the true mind and owner of this company? If you don't drill down to that level, we will always be stuck on a very superficial understanding of what ownership means. Thank you.
Thank you very much. We're going to take questions now until 25 past. So in other words, we're going to try and get as many in as possible until 25 past. In theory, that's 11 people, because that's 11 minutes between now and then. After which, we will have 5 minutes response from each of the presenters. 11 hands, please. From here, help me. 1, 2, 3, 4, 5, 6, 7. Please remember your number. There are 7 hands that are up. Okay, that's 7 minutes. We'll take it after. Thank you. 7 straight questions, please.
Thank you. Speaking as an operational buyer, the thing that buyers liked about the now repealed 2017 regs was that it was implementable, it was specific, it was understandable, and that eliminated confusion and reduced the likelihood of litigative practice due to grievances raised by bidders, because it was very difficult to inadequately allocate preference points for BEE. The challenge we have now is that while the 2022 regs are obviously trying to avoid over-prescribing for good reason, it's vague and it's ambiguous. And that ambiguity, in light of the massively constrained resource pool we have within the supply chain, I hate to use the word fraternity, actually called a sorority, but within supply chain in the state, we don't have capacity to go through the time-consuming, albeit necessary processes that underpin the need for market research and all the other wonderful things we talked about this morning. We need something easy or simple. Maybe not easy, maybe easy is undervaluing. We need something simple that is implementable and understandable.
Thanks. I have a comment concerning a question. I just want to thank the 2 speakers. I think this is a very important conversation, and I want to plead that we go into a solution-oriented conversation. Harmonization, I'm very happy, Prof, that the 2 legislation should harmonize. I would have loved DTIC colleagues to be present so that we can talk about their view about the 2 legislation, because they were passed by the same parliament. So we cannot talk past each other as organs of state. The concern I have is to my National Treasury colleague that I can't speak on BEE. We are colleagues. We need to speak for the same government that we are here for. And I'm speaking from an employee as an organ of state. So we should have conversation with each other so that we can have a common voice. If this requires that task team report, let us talk about it. And the question that I have for the National Treasury is, what Chief Justice asked about the independent office. National Treasury, you are a procuring entity as well. So we need independence. Thank you.
Thank you. Thanks to the speakers, the organizers, all protocol observed. I am here in my capacity as a legal practitioner, and I believe that introduction is not part of my 1 minute that I have. Okay. Very important legislative provisions we've discussed here today, triple PFA and triple BE. I don't think we can stress enough how important that is to procurement. Mine, however, is a more, I would say, substantive question. How can we ensure, and I must add, I think it's related to fronting and possibly to the beneficial question posed by my colleague over there. How can we ensure, because we now have BE advisors and we have people that help companies structure their BE level to get to a level 1, where all white employees, for instance, are employed as consultants, but we both perform the same functions and so forth. How can we ensure that, I mean, we can't force transformation, but how can we ensure that we actually implement transformation and it's not just a matter of rubber stamping level 1 PE for purposes of procurement? Thank you.
Thank you.
Dumelang, my name is Tandy Pino. Thank you for the presentation. I am not from Sandal. I've never seen their offices, so I don't know nothing about Sandal, but I need to ask this much about Sandal. Having clarified the issue of the use of PE as a specific goal, I think most of us know about the quarterly pertaining to Sandal, where they had to go into their old PE tables. And now we know that this is going to be found to be irregular. What then is going to happen in terms of expedition into control for the National Treasury? One. Secondly, in those instances where audits of are taken to court because of their choice of policy, where is National Treasury maybe becoming the friend of the audience of state or a supporter of sort, so that this can be dealt with? Because now we now know that the entire procurement of Sandal is going to be irregular, and then they will account to you for condoning, maybe then be condoned because of the quarterly. Thank you.
Thank you, Sean Scott. Firstly, Yanda, to you and Lily, congratulations for getting a Public Procurement Act. We have that, and that is significant. This discussion that we're having right now is a mess. This legally is a mess. So what is the plan to expedite the effective date so we can get Chapter 4 in place quickly and get out of this mess quickly? What is the plan to do that?
Okay, thank you very much. Let me just direct my questions to the council, which I understand she talked about if you don't have any approved the same policy, for example, you can implement the specific goals. But it becomes a different thing in terms of the AG, where I'm not sure if the National Treasury, they do have engagement with them all the time, because I'm sorry if the AG is here, but most of the times you find that you need to teach them in terms of the regulations, which is wasting our time, because each and every year you teach them the same thing, and then the next time they come, I'm appealing to the National Treasury and the organizers of this conference for next time to invite them to be in the house so that they may understand. And then the second question, Councillor, I think you have indicated that, and also they have indicated that we may not necessarily use the BEE status level contributor as a specific goal. My question is, will companies still advance the BEE if now the BEE status level, I can say it worth nothing for now, and then will they still advance for the sake of the country? Thank you.
Morning, everybody. In the city of Cape Town, we've been May before the full bench of the Western Cape High Court actually dealt with all of these issues, and so it's going to be really interesting to see when that judgment comes out, just for the colleagues who might not be aware all of the arguments that was proffered this morning for either the code or the triple PFA or the harmonious reading of the two pieces of legislation. It's all covered in that arguments that were presented before full bench over 2 days. I suppose my question is only that if one prefers the argument of saying that the triple PE scorecard should be used, how do we prevent funding? Because we know that the scorecards has been used as a mechanism for funding in the past, and so how do we avoid that if we go into a situation where we say that the scorecards should be the reason people in preference? Thank you.
Theo, what's going on?
No, sorry, no, I was asking Theo to give Sisha the mic for when it's time to answer. Yeah. Not now.
Okay, we'll take, is this a question or a contribution? Final question of the assignment.
My question is directed to the council. He indicated that through specific goals, we must give effect to triple BEE. And the triple PFA gives indication of what those specific goals are, and it says may. Is it the council's submission that in the specific goals that are set in each and every tender, there must be a point allocated to BEE level? As he also argues that giving effect to BEE in his reading would mean level, not the broader understanding, or if yes, the broader elements, or if the elements are segmented through other specific goals. Is it the suggestion that in each and every tender there must be a point of specific goals allocated to BEE level?
Here's the final question, and then we go to the responses.
Good morning to the presenters, and I must congratulate you for the way that you presented this morning. My name is Esma Isaacs. I'm from the Department of Health in the Western Cape. I just want to highlight one or two things, and that is, where do we find ourselves as procurement officials? We've got different legislative, interpretive issues with the triple BEE, triple PFA, as well as this harmonious a thing of the two legislation, different pieces of legislation. However, we have the Auditor General as well, and depending on whichever policy position whomever has taken, we have the serious risk of irregular expenditure. So I ask myself, who should be carrying the responsibility for the irregular expenditure in the absence of guidance? And I think that is what we have to seriously look at. Because I think it's about time, and this is just my opinion, not saying we should do it, shouldn't do it, but I think it's about time that we understand that there is a huge tension between legislative interpretation, between what the Auditor General is expecting from us, and what all the accounting policies are requesting from us. And yet, we are all just procurement officials. So, there's something is not right. And we should definitely, this is the time also, that we start standing up for the discipline. Because the way that we are managing it, it's almost as if you left to your own devices. Whether it's going to be irregular in 3 years' time, or irregular in 6 years' time, whatever, you just got to do it. This is not right, colleagues. We have to start taking a really responsible step. We can't continue like this. Thank you.
Thank you very much. 5 minutes each, starting with Peter. 5 minutes, Peter.
Okay, thank you. Let me start with the last question, and that is what's responsibility for when there is irregular expenditure. It's a tough one, but the reality is that when the chips are down, they're going to say, you as the department were solely responsible for making your own decisions, and so you have to carry the can. There was an interesting suggestion which came from the floor earlier, that when you are challenged, especially when there are legal challenges, that that we should be looking to National Treasury to join the fray, so to speak, to come and say, no, but we want to enter into this matter as a friend of the court or whatever, to make certain submissions, to explain to the court why this organ of state has taken the position it is. Perhaps that's something to reflect on. There was also the issue of the AG, that the AG has its own approach and so on. Let me say a couple of things. The AG is not your enemy. So I think I have made myself hugely unpopular now. Because my lunch. But your starting point should not be that the AG is out to mail us or the AG is out to. I come from a public sector environment and I know how easy it is to fall back into that kind of position. Having said that, the AG is not always right. And I think that the AG probably themselves will accept that that is the case. Recently, it was the General Counsel of the Bar decision. They said, you state attorneys, you don't issue tenders for these advocates to appear, and it's all irregular expenditure. The court said, but the anything doesn't even apply to the state attorney's office. It applies to national departments, it applies to provincial bodies, to municipalities, but the state attorney is not mentioned in the PHNA, so how do you even come on? So I'm using that in my illustration. And I don't suggest an adversarial relationship either with the regulator in Treasury or with the auditor being the Auditor General. But there comes a time, as some departments have done in the past successfully, to take findings of the AG on review, and there have been instances when they were successful. I'd suggest that that be done very sparingly. I don't think it should be the norm, because you do want a cooperative relationship. I think maybe I'll just touch on one more. There was some question about funding. If I understood it correctly, someone from the City of Cape Town said, well, if you tell us that we must use the scorecard, which, and my position is that the scorecard must be used together with other specific goals. So I see it in this harmonious way. But the question, if I understood it, was, well, what about funding? Is it of fronting? Oh, I thought you said funding. Okay, so there the scorecard is used for purposes of fronting. Well, the fronting is an evil which is something that we must deal with. And fortunately, there are clear guidelines issued in the Act. There are mechanisms that we can put in place. The fact that there is a risk of fronting is no answer to the argument that the BEE scorecard ought to be applied. The fact that there is a risk of abuse doesn't mean that is no answer to the submission that it should be applied. Let me stop there, unless there's some other things. There's something about the organs of state. Okay, that was about National Treasury. There was some. Oh, the Sandra, someone said about. I don't want to discuss that matter because I was directly involved in it. But just to say that that was nothing more than an initial interdict. The court did not say we find your triple P invalid. The court said, hang on a minute, you changed the preferential procurement system, the specific goals was changed halfway through the tender, you issued the tender, and then shortly after that you said, no, let's take out the BEE scorecard, we give other specific goals. And the main basis for the court's reason was you should have afforded the bidder an opportunity to make a presentation. So I know since the policy has been changed, or so I understand, but the court didn't say don't change your policy. The court said we are stopping you from going ahead, pending the outcome of the review application. I don't even know.
Very quickly, I know the time is limited. The gentleman said something, I think you may have misunderstood me. When I spoke to the title of my presentation, I was not saying that I'm not going to talk about EE, and I think I spent quite a bit of time talking about it. So we have engagements with the DTIC, we've had numerous engagements. We are government, but we also must understand that government has different mandate owners in respect of what they need to do. So we need to also, as the court has told us, we need to stay in our lanes. But we engage and we do have conversations. So let me not be misunderstood around that. Thank you. But with regard to the question of the independence, that's on the topic relating to the bill. Once again, we will have webinars that talk to that. We will explain the rationale for why there are provisions in the bill that look the way they look. Including chapter 4 and how we intend to unfold. I think I won't be doing justice to those questions if I must try to go into that now. I did ask for that my colleague gets the mic prior to us finishing this question, because I wanted us to talk on the issue very quickly of what happened in the transition between when we moved away from specific goals, the 2001 regs, to 2011 when we started introducing BBBEE, and how it was what they did when she was still working at an institution in terms of how they made that work. But I think time is limited, so I'm not, and I don't think she's been given a mic, or have you? Oh, great. Thank you, Susan. And maybe around the system issue that, I think sometimes people are worried that they can't implement things, but if they do it in accordance with the system, they'll be able to do a little bit better than they currently do, and not just do haphazard type of approaches. Thank you.
Thank you, Linda. I think this goes to the question that I asked with regards to having legislation or regulating such that things become easy. I think we need to remember that 2001 actually did not have BEE provisions, and it's more like the judgment took us back to 2001, and those that were in the system at that time, they had to focus on specific goals as they are in the FFA and RTPs. That's what we're doing, and it was working. And right now, actually, that's what we're supposed to be doing. We should not be a bit confused now. We should remember that that's how it was. 2011, when PE was introduced, things changed because 2001, what we do, remember, as Diana has said, that you need to make sure that before you put your specific goals, you have to be very intentional with the transformation and everything else, which means you must have a strategy, you must look at your market, you must look at what you are buying, you must look at what your environment, and come up with a strategy. And that must inform how you are going to actually empower, given that specific thing that you are procuring at a particular time. If maybe say looking at women and you go to break that particular kind of sector and introduce women, you have to be very intentional. And when PE was introduced, that power was taken away from institutions because all of a sudden, all that they had to do is just the scorecard. All the strategies that were there were thrown out because now, even if you want to empower women, what do you do? Because the scorecard 4, 5, 6, 1, 2 is all that you need. So it actually disempowered institutions from being intentional in terms of how they want to empower. And it seems like that is an easier way, and that is where we want to remain as institutions. We just want to just have a number that you put there and you calculate, and then we go. And what was happening after that is that we say, Treasury, we are not empowering us to empower. And what we have now is the judgment that has said, go back to what you were in 2001 and do what we're supposed to do. And the institutions are saying, no, we don't want to do it because it's too much for us. We just want to put in numbers. So what we're trying to say, colleagues, here is that the two pieces of legislation that we say harmonize, these are primary legislation, but we are saying use a regulation of one to harmonize two primary legislation. Is that possible? Maybe we can be assisted in that regard, because what we is engaging in an engagement that is taking us nowhere. Well, we know for a fact that you cannot use a regulation of one primary legislation to harmonize it with the other. What was supposed to happen in 2011, when the decision was taken by Cabinet to say DTIC and National Treasury get married and make sure that BE is actually promoted through procurement. Then, at that point, at a primary level, change was supposed to happen, not at a regulation level. So if we're looking at the regulations and saying regulations harmonize two primary legislation, is that practical? That is where the mess is. So when we continue with that conversation, two things. It's either we know for a fact it's not going to happen, but we continue doing it, or we push for the primary change. And the bill, the Act now, Chapter 4 of it, is the tool that enables it, because it's going to at least repeal one and be able in our engagement to bring two together. So there is that process. But as also my colleague has indicated, BE scorecard is a challenge. But when you look at your strategy, the contribution that is required through PPFA will contribute to the intent and the object of the BE score, of the BE Act. So that is the contribution of procurement toward the job. It's important that we see it. That is actually I wanted to add to what my colleague had to respond to. Thank you.
Thank you so much, colleagues. Thank you. I want to give our thanks to Leander and to Dr. Baldwin. Thank you so much. That was, I think, obviously very engaging and interesting session. Thank you for honoring our invitation. Thank you for your willingness to be in the hot seat. And thank you, colleagues, for being here, for participating. We're going to lunch now. We have an extended lunch period because, as you know, the aim of these sessions that we continue engaging, speak to one another. If someone that's raised the question or comment that you don't agree with, find them, debate with them, fight them if you have to. It's not easy. Right? And let's keep the conversations going, and we'll reconvene here at 5 minutes to 2.
All right. So before we break for lunch, just one or two things that I wanted to just wrap up before we go into lunch, and also to get you thinking about lunch and what we come back to. So I think what's really important for me is that something that's come up now in this last conversation very clearly, but also very clearly in the Chief Justice's comments, and that is the importance of this community realizing its agency in this space. And that is very much what Proshop and I are hoping to help facilitate. I mean, we can only create space and the opportunity, but we really hope that through these engagements, we can do that. We can, as a community, come together and say, let's take ownership of all of these things, and let's be the agents of change that we think must happen in this space. Let's not be passive. Let's not sit back and wait things to happen to us. Let's together form a community. And that's really a great segue into this afternoon session as well, where the theme that we want to pick up this afternoon, and those were we have two themes that we wanted to discuss at this particular workshop. One was the regulatory space we're in and that we're moving into. The second one is capacity building. And this afternoon we want to spend a little bit of time focusing on that. How do we go about, as a community, building that kind of capacity we need, and with that, building our profession? How do we become a real profession? where we can be the leaders in this field. And that's what we're going to talk to. Before we go there, I want to just do one quick thing. To my shock, I discovered over coffee that our colleagues in National Treasury, and particularly in the Directorate, you must help me now, what is the name? ACM, Policy and Norms, right? Norms and Standards, there we go. Who were the primary drivers of Act 28 to 24, right? So when I wake you up now after this workshop, I ask you 28 to 24, what does it mean? You should immediately start, right? You can that. So they were the primary drivers of 28 to 24. And yesterday had this important moment, crowning moment, but they've not properly celebrated it. And it shocked me. So I want to ask Mr. Matabula, Ms. Peterson, you're here. Ms. Sishle, please come to the front. Mr. Bale, you're here as well. Any of your other colleagues that I've missed, please come to the front. Come, all Treasury colleagues, please join us in the front. Ms. Liana, you as well. Where are the other colleagues? Because, ladies and gentlemen, I think as a community, we owe a thanks and a congratulations to this team. But before you clap, hang on. Before you clap, as is appropriate when one celebrates, especially when you come from Stellenbosch as we do, you need the appropriate means to do so.
Yes. Wow!
I will give them this bottle of Jason LaRue, but
yes.
I'm mindful of the fact that you're working in Treasury, so it's a non-alcoholic version. It's appropriate to open it in the office. Please open it and celebrate. And from our side as a community, congratulations on a massive achievement.
Yay.